give his speech. He has been an MLA before this for 10 years. More importantly, he has not at any time limited himself to Hyderabad in the parliament, but has always voiced the Muslim community's concerns in the parliament. He is also an excellent example of what a person
Thank you, Shafi. It is really a tough task for me to speak at this time of the afternoon and to keep all of you awake. But let me try to be as erudite as Javeed Alam has been. I just like to break up my speech in 4 parts. Now, part 1 is that the Indian judicial system is defined by rule of law. And the rule of law stands for supremacy of law. And the Indian legal system should be fair, predictable, and rational. Now keep these 3 words in mind: fair, predictable, and rational, and rule of law. And what did Mark Twain had to say about India? He said India is the cradle of human race, birthplace of human speech, mother of history, grandmother of legend, great-grandmother of tradition. This is what Mark Twain had to say. Now, when you come to this exact judgment, before I go into the legal aspect of it, historically, I'm sure many of you know, must have read it, that this Babri Masjid was built in 1528. And in 1570, if I'm not wrong, Tulsidas wrote Ramcharitmanas. And Tulsidas was of 30 years at that time. So, if, let us say for debate's sake, that a masjid, that a mandir was demolished, and that to a birthplace of Ram was demolished, and a masjid was constructed, I'm sure Tulsidas would have reflected in that. You do not find in that. Secondly, Babarnama was written. You do not find in that. Aine Akbari was written. You do not find in that. Then William Finch wrote a book. No mention was made about that. It's only in 1880 or 1875 that a Ram Chabutra came into existence outside this masjid. Then subsequently, Sita Ki Rasoi also came to the southern side. These historical facts were completely ignored by the honorable judges. And the most important point is that one of the speakers had said that Ram was born in Ayodya. There are many people who say that Ram was born in Patiala. Why? Because even now, unfortunately, this is a tradition which all of us must break. That if anyone's wife gives birth to the first child, she goes to her mother's place. So some people say that Ram was born in Patiala. Now, that is also debatable. Swami Agnivesh says he was not born over there, he was born somewhere in Ayodhya. Swami Agnivesh says no, he was not a god, he was a man. And according to historians, if I'm not wrong, I'm speaking in front of many experts over here. As Javeed Alam has rightly said, that human race scientifically could be, we can go back 3,000 years ago. But here you have the Honorable High Court judges deciding a point which, or deciding an incident or a birth of a person which took place 17 lakh years ago. So you can very well imagine the kind of intellectual capacity they have. That even Romina Thapar does not have, Irfan Habib has no match in front of these honorable judges. So the honorable judges, I mean, I'm sure, if these people continue in service, they can one day bring laurels to Indian judicial system. Because they have decided an incident which happened 17 lakh years ago. And Karunadi rightly said that the South India people would like to know where was Raja Chola Chola born 1,000 years ago. And another aspect is this judgment hurts the pluralism of India. And Karunadi says that this whole agenda was artificially captured by a homogenized community which was more interested in Ram and what happened 17 lakh years ago. So this in itself is antithesis to our pluralism. And when I started by saying that the Indian legal system should be fair, predictable and rational. And if judicial statements do not go hand in hand with rationality, with being fair, and they do not, then where do our rule of law goes? The rule of law goes out of wind. You don't have any rule of law over here. Coming to the second aspect of my speech is 1528, as I told you, this masjid was constructed. In 1949, till 1949, the last prayers were done over there, the Isha prayers, the evening prayers, last prayers of the day. On 23rd December, surreptitiously, some people owing allegiance to the RSS and to the Sangh Parivar went inside this masjid, opened the locks, some people jumped over the wall and placed the idols of Ram in the sanctum sanctatorium of the masjid. Every masjid, if you can walk into any masjid you want. And there you will find that the main part of the masjid is known as mimbar. Right on the first step of mimbar, these idols were placed. And subsequently an FIR was issued. And in that FIR it was clearly mentioned that these people had trespassed and placed those idols over there. It is a different thing that Advani says and RSS people say that Ram appeared over there. I'm just trying to build my case and start from where Javeed Alam left. That Ram appeared over there. Now, if I do something wrong over here, let us say I trespass into your esteemed college, and I say, no, this is my place. The first thing that is done is you go and tell the police. Police registers an FIR, and then 145 CPC says that immediately that trespasser is evicted. Nothing is seen whether I have the title or not. First thing that is done is, because I have trespassed into your peaceful possession, I am thrown out. And then the civil title suit should be decided by the courts of law subsequently. But over here, what happened? And that is why you see that if you follow the sequence of events from 49 till the 30th of September of this year, Muslims and people who believe in the ethos of secularism are angry and upset. And it would be an understatement to say that they are angry and upset. And their angerness and upset is a genuine grievance. Because in what has happened in the last 60 years, the 30th September judgment is a crowning moment on judicial injustices that have been done to the Muslims community. 1950, a court receiver is appointed. And see, if I barge into your house and place something over there. Let us say I put my religious, something over there. And then you say that, no, this is my house. Instead of the administration coming to a rescue, the administration says, no, this does not belong to you. Asaudin Owaisi will come over there and offer prayers inside your house. You will say, what the hell is this? Is this justice? This is my place and you want to come and pray over there? A receiver was appointed and that receiver said, I am appointing 3 pujaris. They will pray to Lord Ram and Muslims' case will decide. Muslims, this matter went to court. 1950, you will be amazed. The High Court of Allahabad made the injunction absolute. And when you say the word absolute in legal terms, that means the puja will continue inside a masjid. 1960, the Sunni Central Waqf Board became a party. From 1960, they have been fighting this case. 86, the locks were opened. If I am a dispute to a legal case, natural justice demands that I should be given a notice because I am a party to that dispute. Without even a notice being given to the Muslim community or to the Sunni Central Waqf Board, the court decides on this matter. It comes on the day of where the lists are issued. And one Muslim lawyer by the name of Mr. Mushtaq, he comes to know that this is going to be heard. He runs from pillar to post. And at 4:15, when the argument starts at 4 o'clock in the evening, 4:15, the argument was about to finish. Mr. Mushtaq goes and says, sir, I am appearing on behalf of Sunni Central Waqf Board. So the Honorable Magistrate says, oh, you have arrived. He listens to it for 1 minute. He says, okay, thank you. And within half an hour, an 11-page order is given. And in those days, you did not have computers. You had to physically ensure that your steno types all these whatever order. 11-page order was given on 4:30. So that in itself clearly shows that either the typist held a world record or it was typed the night before. An 11-page order was given. That is to open the locks and for all the people who believe in Ram to come inside a masjid and offer their prayers according to their religious belief. The Muslims went to the High Court. High Court made their order absolute. That, gave a status quo. And amazingly, the status quo means that what it was before. According to the court, status quo meant no. We can go inside and pray. You had Shilanyas. You had 91, another incident happened, and 92 subsequently it led to demolition of Babri Masjid. Now when Mr. Ramakrishna started, I'm sorry sir, when Mr. Satyanarayan started, he said he does not believe in the judicial system for various reasons, rightful reasons he has listed. Can you please understand that after the demolition of Babri Masjid, a suo motu contempt notice was issued. People went to Supreme Court, as Javeed Mr. Satyanarayan had pointed out, Mr. Javeed Alam was also pointed out. We made a notice to Supreme Court. And now you have Justice Ahmadi, 10 days ago saying that Supreme Court could have saved the Babri Masjid. When Justice Ahmadi was Chief Justice of India for 2 years, he ensured that this contempt petition does not come from the Supreme Court, leave aside in front of him. 18 years have passed, this contempt petition has not been heard. That is why we are angry. That is why we have this grave sense of injustice. And then you see commentators saying Kalyan Singh was given a one-day sentence because he could not protect the masjid on 6 December 1992. Again, this is a huge mistake. You are being misled. Kalyan Singh was not sentenced for dereliction of a constitutional duty of 6th of December, but he was sentenced for 1 day because he had constructed